Good afternoon, everybody. Today is Sunday, February 15th, and this is Truly Sinister. My name is Wendy. Welcome. Um, I hope everybody had a good Valentine's Day. I hope you treated your loved one to something special. Like I said the other day, you don't have to spend a lot of money to just show someone how much you care. You could do something out of the ordinary, like bicycle ride and a picnic or anything, romantic bubble bath, cook them dinner, whatever. So I hope everybody had a good one. We had a good one. We just went out to dinner. Of course, my husband was still a little groggy and a little under the weather after his surgery on Friday, but it went well and he seems to be doing okay. He seems to be warding off the pain. We're staying on top of the pain meds, so they said not to let the pain come through because once it breaks through, you'll just be chasing it. So we've been doing that since Friday. Today, I just kind of wanted to go over the Edrick Faust trial. It's Georgia versus Edrick Faust. It's a cold case, 24 years old. It's Tara Baker's case. She was unalived in 2001. She was found in her apartment right off campus. She was the first year law student at the University of Georgia. She was 23 years old. There was a fire in her apartment. The fire department responded. After putting the fire out, they found her body in her locked bedroom, locked from the inside. All the doors to the apartment were also locked, dead bolted. There was no sign of a forced entry. She was also stabbed and ultimately strangled with a power cord from a printer. And there were multiple hairs found both on her body and in her hand, on the printer cord, none of which belonged to Edrick Faust, the defendant. She had a on again, off again boyfriend, long-term boyfriend, Chris Melton, whose hairs were found on her. His semen was also found in her, backyard area, which he confirmed with police they never partook in that type of sexual activity. Apparently, some DNA was found in her oral cavity, and they claim that it is Edrick Faust's. However, they lose that evidence. They open the envelope in trial, and the envelope is empty. Or no, I'm sorry. They mislabeled it, and they had two oral swab samples, but one of them came back vaginal swab, and that was, I believe, Christopher Melton's DNA. So DNA that matched Edrick Faust was found in her mouth. But there's no other signs of him being in her apartment. There's no DNA, there's no fingerprints, nothing. But 24 years later, he is arrested shortly after they enacted the Baker, I'm not sure what the other name is, something Baker Act, which is they were granted $5 million to start a cold case unit. And they wanted this unit to start solving some of these unsolved murders. And of course, the first one they chose was Tara Baker, who is half of that act. Her name is, and it just so happens that that's the first cold case that they solve, supposedly. This case is probably just as bad as the Karen Reed case as far as the judge holds does not hold back her disdain for the defense attorney, Ahmed Cruz. He's a quote unquote big city lawyer from Atlanta, which we all know these small town judges do not like, especially the female ones. But her patronizing and condescending attitude towards him is so apparent. She doesn't hide it for a minute. And she is so biased. She's not impartial at all. He actually asked for her recusal, and she heard that motion, of course, just like Beverly Cannoni heard the motion from Alan Jackson, and she denied it. Just like pretty much every motion that he files, she denies. She keeps, when she talks to him, when he makes an objection or files a motion, the first words out of her mouth every time are, I don't understand what you're saying, Mr. Cruz. I don't understand what you're getting at, Mr. Cruz. Like he's stupid. Like he doesn't know the law. She makes it sound like he doesn't know what he's talking about. And she'll follow that by saying, what I think you mean to say, or what I think you don't know, or let me tell you about the law. It's like, or you need to learn the law on this. It's constant, and it's so aggravating that Mr. Cruz actually stood up in court and told her at one point, I used to love this job, but it pains me to come in here every day because of how I'm being treated and how my client is being treated and how this trial is being allowed to carry on. And of course she had no sympathy for him. I mean, she is just a non-empathetic bitch. And there's no other way to put it. It's disgusting to watch, to be honest with you. And then the DA, what a prick. I mean, he's just as condescending and just as, ridiculous as the judge. And it's almost like they tag team Mr. Cruz at every possible chance they get. And it's hard to watch. It really is. And that's why I say it's a modern day lynching, because there's no proof that this man was ever in Tara Baker's apartment. None. But there's all kinds of evidence that her ex-boyfriend, Christopher Melton, was there. And he wasn't supposed to be. He tells the police 23 years ago or whatever that it was 10 days since he saw her. And the GBI detective that was, assigned to this case, you'll get to hear from her too. She's something else. She basically is just telling him, I need to be able to justify your semen being inside Miss Baker. So you need to tell me that you saw her less than 10 days ago. And she's basically telling him, we need to justify, we need to explain your DNA away. So you need to say that you saw her. She goes, was it just a booty call? Was it just a quickie? I mean, maybe you forgot, until he finally, has that aha moment and says, yeah, I think I did see her with, less than 10 days prior. It's disgusting. And this detective, if you can call her that, used to work on the sex crimes unit. And if this is how she behaved when she worked on the sex crimes unit, God help any victim that ever had to deal with her, because she has no empathy. She's just a bitch, And she literally came out and said, well, why would Edrick Faust's DNA be in her? I would expect Chris Melton's DNA to be in her. Why would you expect that? Even if they were together still and, weren't broken up, why is it automatically acceptable for the boyfriend's DNA to be inside a woman's anal cavity? If he admitted to them already that they never had that type of sex. So why would that be expected? Because he's white? Is that why? And then they try to explain it away by some the drainage of the, semen from the vaginal area to it's disgusting to listen to. They have no evidence. The prosecution literally spends the whole trial defending Christopher Melton rather than prosecuting Edrick Faust. And you want to know why? Because they have no evidence against Edrick Faust. None. They needed a fall guy. This is my opinion. They needed a fall guy to, solve this cold case, because it has to be the Baker girl whose case is solved, the first case solved. I mean, come on. We have to justify and make them know that this $5 million they gave us for this special unit is being well spent, right? And how better to show them than to solve Tara Baker's unaliving. There's just too many coincidences and too much shit to sift through to ever say that there's no reasonable doubt. Now, I'm not saying that Edrick Faust is an innocent man, because he does have a criminal background, a criminal record, but he definitely hasn't been proven to be guilty of this crime. And if he is guilty, then shame on these officers for doing such a shitty job investigating to where he can be found not guilty. And there is so much reasonable doubt. The reasonable doubt, they have pictures of Chris Melton's hands just days after this horrific, scene takes place, and his hands are beat to a bloody pulp. I mean, and it's like, if that doesn't cause, reasonable doubt right there alone, then the jury is just as biased as the judge, in my opinion, because there's he may not, like I said, he may not be innocent of this crime, but there definitely is enough reasonable doubt to find him not guilty. There's no way, if they find him guilty, that it's a fair trial. And I think that Mr. Cruz is doing a really good job setting it up for appeal in case he is found guilty. He doesn't even give he doesn't even give a rebuttal case. He rests. He doesn't call one witness. And I think that's probably the best thing he can do, because that helps him out when it's time to file an appeal, should he be found guilty for this. So today I just wanted to go over, show you a few videos, a few clips to show you just what's going on in this Georgia courtroom, to put boots on the ground. But I know that Melanie Little, she's had a few people from her channel show up and sit on the side of Edrick Faust. He had family and friends protesting in front of the courthouse this last Friday. And I just think that more attention needs to be brought to this case. And I'm just sorry that we're already at the deliberation stage before I got this video out. But it needs to be shown everywhere, and everybody needs to see what's going on here. It's ridiculous, and it shouldn't. I just can't imagine that shit like this goes on in 2026. I mean, I thought we were beyond the whole race thing, but this trial, I can't think of any other reason that the judge and the prosecution is behaving the way they are, other than the fact that the defendant is of color, and so are both of his attorneys. So if you can give me another reasonable answer for their behavior, I'm willing to hear it. But I am telling you right now that it just smells to high heaven, and something should be done. They shouldn't be able to get away with this. And the jury will begin deliberations on Monday. They are not acknowledging the holiday. And I'm not sure what will come of it. I can only pray that they do the right thing and find him not guilty. But you never know. You just don't. I mean, these people all live in Georgia too. Is that still the majority mindset in Georgia? Because if it is, this guy's in trouble. And it just breaks my heart that it comes to this. You know what I mean? He, yeah, there's just too many things that point to Chris Melton. And I'm not saying that Chris Melton is guilty, but I think Chris Melton could be a strong suspect. And if you have two suspects that aren't related, do not know each other, have no tie to each other, then who do you bring to trial? Well, here they brought the black man to trial and did everything they could to defend the white man. And as far as spending a whole criminal trial defending him, every single witness was questioned about Chris Melton and the possibility of him being the, the person who committed this crime. And it's just, they never even checked his alibis. This cold case detective, she never even confirmed that his alibis were true. She just said, well, why wouldn't they be? I mean, well, because that's part of your job, is to confirm alibis and make sure that people are telling you the truth. And apparently Chris Melton just seemed like the kind of guy whose word they could take as honesty. And it's they did not have a case against this man. It should never have been brought to trial. He should never have been charged. And I'm not saying that Chris Melton should have been, but if they didn't think that there was enough evidence, if they thought there was enough evidence to charge Mr. Faust, then there was definitely more than enough evidence, using their scale. There was definitely more than enough evidence to arrest and charge Christopher Melton. So, you can't have it both ways. You can't say that, yeah, there's a lot of fingers, there's a lot of stuff pointing at Chris Melton, but he was her ex-boyfriend, that stuff is expected to be there. And you can't say that. I mean, have they never heard of boyfriends and husbands graping their spouses? I mean, it does happen. Not a lot, but it does. They're, just because they're married or they're a couple doesn't mean that they can't be graped by their significant other. And so for them to say that it would be expected to find Chris Melton's semen inside Tara Baker is just a lack of astuteness, and it's a very poor detective work as far as I'm concerned. Because if they were broken up and he hadn't seen her in 10 days, there's no way his DNA should have still been present. And they get that. They get one of the experts to admit that. So it's like, well, and they even say that in the backdoor region, it lasts even less time. So we're talking 24 to 48 hours, and it would be, unrecognizable. They wouldn't be able to get a sample to test. So even him saying that he saw her within the 5 days is too long. So how does he explain that? They didn't talk to anybody about the wall he supposedly beat the shit out of, which is why he says his hands look the way they do, even though there's, obvious signs of what I feel are teeth marks on some of his fingers. Then they showed the knife, and it looks like there's plumber's cement on the knife handle, and he was a plumber and said that he possibly could have had plumber's cement or plumber's glue on his hands at the time of his police interview, but he can't remember, So it's like there was just too many coincidences that lead to somebody other than Mr. Faust. There's nothing that points to him other than the fact that his DNA was in the CODIS database, which is, anybody that watches true crime or anything knows that the CODIS is the database where if you're convicted of a crime or accused of a crime, I don't even think you have to be convicted. they take a buccal swab inside your cheek and your DNA goes into this database. And true, they do, missing people, their DNAs can be found in this database, but it's mainly known for felons. I mean, let's be realistic. And the judge allows it in, even though they're not allowed to bring up prior convictions or prior criminal history. The judge allows to bring in the database and how his DNA, how he was identified as a suspect. Well, anybody with a brain knows that the DNA database that they're talking about is most likely CODIS. And most people are in CODIS due to a crime that they committed or were accused of committing. So they just give him this lawyer the absolute runaround, and she even, you'll see. So let's just kind of get going on this, because it's unbelievable, the shit that is going on here. Okay, this video is of Mr. Cruz being found in contempt. This is, I believe, the first day of trial. It's just sickening. And then the next day, she accuses him and throws it out there in a snarky way that, you were 15 minutes late for court today, and we waited for you. Well, the reason he was 15 minutes late for court is because he had to go and pay his fine before he could come up to the courtroom. And the court doesn't open till 9, I bet. So, enough with the fucking little snarky comments and the attitude. Just be a judge. How about that? It's just disgusting that most of the judges that behave this way are women. From, McCarthy Nyman in the Kelsey Fitzsimmons case and her behavior in the courtroom. Judge Barbara Elmore in the Aaron Spencer case and her behavior throughout the pretrial activities, or whatever you want to, hearings. Both of those judges have been recused by the higher court, which thank God, because neither one of them have a right to be seen over either one of these trials. Elmore definitely has a conflict of interest because she let the perpetrator out on $50,000 bail, and he went right back to offending against that 13-year-old girl, which is why her father ended up killing him. So, yeah, I'd say that's, how can she settle on that trial? That's a definite conflict of interest. McCarthy Nyman, I don't know what kind of connection she has to Kelsey Fitzsimmons' trial, but she has a total, she was visibly shaking. She was so mad at Timothy Bradle and Kelsey Fitzsimmons one day. And the way she chastised them, it was totally unprofessional, uncalled for. And I'm glad that the higher court recused her, as she should have been. Then you had Judge Cannoni in Karen Reed, both of Karen Reed's trials, and she should have been recused because there were numerous hints that she might have been connected to some of the people involved in that case. And it doesn't even matter if it's true. What matters is, how does it appear to a third person, non-interested party? Would it appear as though she had connections or had a bias against the defendant? And I don't think you'd have to be deaf and blind to say no. But she decided to deny that motion. She heard the motion herself, of course, and she denied it. And so she ended up sitting for both trials. And thank God Karen Reed was eventually found not guilty. But it's all women. And it's like, what the fuck are you trying to prove? I mean, and this judge doesn't even wear a goddamn, I'm sorry, a judge's robe. I haven't seen her wear a robe once. Now, to me, that is total disrespect for your profession. What's wrong with wearing your judge's robe? Because what you're wearing, to me, doesn't appear to be any sharper looking. I don't know if you're going for a fashion statement or what, but I guess because she's the head judge of the criminal superior court, I don't know, but she thinks that she's above it, and I think that it is wrong. And I think that she should be made to wear her judge's robe. That's what makes the distinction between her and everybody else in the courtroom. Even though we know she's the judge, to me it shows so much disrespect for her profession that if I were a judge, I'd be irritated by her not wearing her judge's robe. So anyway, this is I believe this is the first day of court, and listen to what happens. Here we go.
I do, Your Honor. Mr. Yalamanchili and I had talked in anticipation of us getting to this point over the weekend. That since I had made opening statement,
Pull that microphone towards you. Thank you.
that I would object since I had made the opening statement, but since Mr. Yalamanchili had made the 412 arguments in the past that he would handle.
All right. Thank you. Go ahead, sir.
Your Honor, as the court's aware, as the state's aware, if Mr. Cruz wasn't aware before we started all the pretrial motions in this case, he ought to be aware now. Making reference, whether it's a statement made by some other witness, whether it's elicited in direct examination, cross-examination, or any other method, to a relationship between Ms. Baker and anyone else that was not noticed by the defense as a
I'm sorry, just a second. Let's see what's going on.
.412 Act. I'm not sure how much clearer the statutory language could be. Not sure how much clearer the court could possibly have been in its with law enforcement, or whether it's Mr. Cruz eliciting the testimony on direct examination or cross-examination. It is all prohibited by the rule. Now for the second time in his opening statement in an interview to law enforcement for the analysis of whether or not it is admissible and the methods that must be adhered to if the defense intends to admit it in any way, shape, or form, Judge. And so this is the second time before we've called the first witness to the witness stand that Mr. Cruz has violated 412 in what seems at this point to be an intentional pattern to try to work his way.
And you'll see in a lot of these clips that I'm showing that this is the actual DA, district attorney. He's helping try this case. You will see that he is, the best way to describe him is a little tattletale. It's like running to mommy and telling every fucking thing that he feels it has to be spoken out loud. And he's so condescending and so rude. He's disgusting.
Around the laws and rules of the state of Georgia as it relates to admissible evidence in cases involving allegations of rape and aggravated sodomy, Your Honor. So again, at this point, I don't know what the remedy is that the court wants to enact, but obviously telling Mr. Cruz not to do it isn't effective because he's not listening and he's not following the court's orders.
Thank you. Cruz. Any response?
Absolutely. I'm actually blown away and in shock that the state is taking this statement to be a 412 argument. Our theory of this case is that Chris Melton committed this crime. Chris Melton's statement, when he's confronted with DNA that he already knew was present, that she was with someone else, it has nothing to do with us trying to get around 412. That statement is for the sole purpose of showing his consciousness of guilt. He knew this information in 2001. He told the exact same information in 2024. And his response isn't, oh, my girlfriend, I can't believe this happened, you guys better find her. His response is just simply to say, oh, well, must be me, she's with somebody else. There's no evidence that I intend to present that Chris Melton knows about Ms. Baker's sexual history. There's nothing I can intimate that Ms. Baker knows, that Mr. Melton knows about Ms. Baker's sexual history. The purpose of that statement has nothing to do with her character, under 24412, her sexual character. The purpose of that statement is to show Chris Melton's response. When he's presented with some evidence, he gives a response that's inconsistent with the person that is innocent. So this isn't a 412. I understand the state may not like what I present, but that does not mean I have to preview every single statement I have to them so they can prepare their case. This is open statement show. I respect the court. I do anything for this court. I've told the court that multiple times. This is not a 412 argument. This is Chris Melton, who knows nothing about Ms. Baker's sexual history, being confronted with a piece of evidence and making a statement that shows consciousness of guilt in our court. This has nothing to do with sex.
All right, thank you. As this court has stated multiple times, this is the second time today, multiple times during hearings, that there is a process that must be adhered to in.
And mind you, I went all the first few days of the trial thinking that he had never filed a motion 412. And come to find out, Melanie Little paid to get the records, and he did file a motion 412. So this lady talks to him like he's a piece of shit that's not following court, mandates or whatever, and he is following them. I mean, it's just, there's still motions that were never ruled on, and the trial's over. I mean, how does that happen? All this shit should have been done before the trial ever started. Every motion should have been ruled on before the trial even started, and yet there were multiple motions that Mr. Cruz filed that were never ruled. Trial's over.
In order to get the appropriate permission from the court to introduce statements, evidence that another party objects to. In this particular case, it is a 412 motion. We have talked about this over and over again. What I have said over and over again is that the defense has failed to file a motion under 412. The state did. The defense has failed to file a motion, and I've said many times that if the defense files a 412 motion, even though it's not timely, the court will consider it. There has been no motion filed. Mr. Cruz, you've been made aware many times that you are not to bring in this kind of statement. I mean, I realize I have said several times today that opening and closing arguments of the attorneys and arguments are not evidence, and I'm going to say it again when the jury comes out. But you've been told many times that in order to, I'm talking now, Mr. Cruz, thank you. You have been told many times that in order to present statements like that, ask for the admissibility of evidence like that, you have to file the proper motion. And the court may consider it even though it's not timely. As I just stated 10 minutes ago, I do find your statements to the jury to be avenues to circumvent 412. And it is not appropriate. I'm finding you in contempt of court. You have had the opportunity to explain yourself, and I'm fining you $1,000. And you are to present that $1,000 tomorrow morning by 9 a.m. Put it into the registry of the court. And that is my sanction for continuing to not abide by this court's orders. I don't know how many times we're going to have this, but it.
So, what do you think about that? I mean, the tone in that judge's voice tells it all. It just does. She can't stand Mr. Cruz, and he is so polite and so, he really holds back. But there are times when he really, just says, you know what, it can't hurt me anymore, and it can't hurt my client anymore to just speak up finally, because it's ridiculous. And I feel like he's just thrown his hands up. I mean, what do you do, right? So now we're gonna we're gonna play, I believe this is a little mix of different clips of some of the finest moments in this trial. And so let's move on, shall we?
Y'all may be seated. Yes, sir.
And mind you, when she sends the jury out for these objections and whatever, she lets the witness stay there on the stand and hear the whole argument. So the witness hears what the prosecution wants them to say and how they want the witness to answer. So when the jury's brought back in and they resume questioning of that witness, they know how to answer the questions for the prosecution. They know what the prosecution wants. They know how they want the prosecution they know how the prosecution wants them to answer. I've never seen anything like it. Every witness stays in court and listens to the arguments. It's insane. I don't know. I've never seen it before, so I don't know if it's common or what, but it's crazy, to be honest with you. So let's move on.
I'm moving for a mistrial. We raised a objection to lack of foundation. The case is Monroe v. State, 340, Georgia appeal.
Let's go back and show you. I mean, he looks at his co-counsel and he rolls his eyes while he's taking his seat.
The case is Monroe v.
Y'all may be seated.
Watch right here.
Yes, sir.
And I'm moving for a mistrial. We raised a objection to lack of foundation. The case is Monroe v. State, 340, Georgia appeal, 373, 2017. It provides that the Honorable Court has wide latitude to admit demonstrative evidence, and the burden is on the party offering demonstrative evidence to lay a proper foundation establishing a similarity of circumstances and conditions. Although the conditions of the demonstration need not be identical to the event at issue, they must be so nearly the same in substantial particulars as to afford a fair comparison in respect to the particular issue in which the demonstrative evidence is directed. Further, experimental or demonstrative evidence, like any evidence offered at trial, should be excluded if its probative value, and the case goes on. But we emphasize the language that we stated. Your Honor, we raised a lack of foundation objection. Your Honor alleviated the state of their burden to prove any type of substantiality between the tests that Mr. Agent Grove, is that correct? Engineer Grove conducted and allowed the state to introduce its demonstrative. Once the bail is wrong with the jury, it cannot be unwrong. As we've said throughout this trial, Mr. Faust's defense has been handcuffed. The state has had free reign. It's to the point where our objections aren't even acknowledged. So, Your Honor, based on Mr. Faust's due process rights, violation of Mr. Faust's due process rights, and the entry of this exhibit, we would ask that the Honorable Court grant our motion for mistrial.
Thank you. Mr. Yelman-Chile, any response?
Your Honor, the foundation for the admission of the exhibit was laid. We haven't gotten to any of the questions as far as, what testing was done by Mr. Grove. We went through his qualifications. So one, the motion is untimely, but even fast forwarding for the purposes of, and I would just note for the record, the only thing that's been displayed to the jury is a picture of the exterior of 160 Font Drive. So, but just fast forwarding a little bit, Your Honor, Mr. Grove received information. He tested certain things that were part of the theory as far as how the fire began in this case, and those are contained in the report. I would also note for the record that Mr. Cruz had an opportunity to review this PowerPoint last night in its entirety. He did not raise any kind of issue with the court prior to bringing the jury in. It's certainly, one, it's not even improper, but two, it's not grounds for
Mr. Cruz, you got Mr. Cruz, I'm going to let you respond because it's your motion, but you need to let Mr. Yellowman-Chile finish his statements. Go ahead, sir.
I said that the evidence is not improper. I'm making no personal attack on Mr. Cruz, but additionally, there are no grounds whatsoever for a mistrial based on this, which is properly authenticated and admitted evidence as a demonstrative aid, Judge.
All right, thank you. Mr. Cruz, anything further?
Absolutely, Your Honor. The Honorable Court, at the conclusion of court, allowed us the opportunity to view this demonstrative. The state, in multiple arguments, has insinuated that I have to run everything by them and then run it by the court. The law is the law. Regardless of how Mr. Yellowman-Chile feels about me, the law is the law. This isn't anything personal. We're advocating. He says Mr. Faust did it. I say Mr. Faust is innocent. This should not be admitted without laying a proper foundation. It is admitted without a foundation. He's saying, hey, Your Honor, we're going to go through the questioning while we're showing the jury what the exhibit is. That's not the law, Your Honor. The law says that before they could present demonstrative evidence, they have to lay the proper foundation. That was not laid. The Honorable Court admitted it without even hearing us out on just denying our objection. So, Your Honor, Mr. Faust is not receiving his due process rights. I am requesting a mistrial.
Thank you, sir. All right. So first, I just want to respond, Mr. Cruz, to your
You can just hear the frustration in his voice. He's at a loss. He doesn't know what to do.
comment that the defense is hamstrung, that the state has free reign. It is unfortunate that you are, as an attorney in this case, responding to the court's rulings in that way. The court certainly endeavors in every way possible to make rulings according to law. And it is unfortunate that you feel otherwise. That being said, you have asked for a mistrial. I'm denying that motion. Trial whatsoever in this particular moment. This is a demonstrative aid. It has been admitted into evidence, but demonstrative aids do not go back to the jury. The state is correct. They did provide you the opportunity to see that demonstrative aid. They did not have to do that, but they did. You are mischaracterizing the court's rulings, Mr. Cruz, in suggesting that this court is somehow forcing you to show the state your hand without making them do that. That doesn't fit any of the scenarios in this case so far. And that is a mischaracterization that is pretty frustrating for the court to hear. There are no grounds for a mistrial. The state has properly authenticated this particular aid, and the foundation has been laid. There has been no violation of 403. I find that this moment has not even suggested that 403 is even in jeopardy. And I'm making a finding again that the evidence is, at this point, not improper. This is a demonstrative aid, and I'm denying your motion. You may bring the jury out.
Yes, ma'am.
You all may be seated. Yes, sir.
Your Honor, I am again moving for a mistrial. We can't impeach witnesses. We can't argue consent. The state can present things that we can't present. We can't rebut allegations in their indictment. We are requesting a mistrial. This is not fair. This trial has been worse than practicing in communist Russia. He doesn't stand a chance in this courtroom, Your Honor. The witness made a prior statement. We played the recording for the court. The witness made a prior statement. He was wearing like an orange-colored shirt, orange or red, something bright. That is a quote. We played the recording. The Honorable Court was able to hear that recording. Her testimony here today was that he was wearing a hoodie. This is important because the state wants to make all the people that were seen in the neighborhood Mr. Faust. The person that they brought the first witness in for said, oh, he had a jacket. So, of course, they want her to say, oh, he had on a hoodie. It's an inconsistent statement. We are handcuffed, Your Honor. We are asking for a mistrial in this case.
Thank you. Mr. Bolden, do you care to respond before I make a response?
Your Honor, Mr. Cruz has failed to make the proper foundation for a prior inconsistent statement. He has not asked the witness a question that the witness then denied. And so it's just not a proper foundation. So that's the basis of the state's objection. As to his motion, I don't necessarily think I have to make a response.
All right. Thank you, Mr. Bolden. So, Mr. Cruz, the first thing I want to say, and we are outside the presence of the jury, is that it is unfortunate that your constant comments about the unfairness of this trial it's very unfortunate. It is outside the presence of the jury, but it is not appropriate to continually just argue to the court that things are unfair and that somehow the defense is handcuffed because of the court's rulings. As I stated before, the court endeavors in every respect to make rulings based on law. So that's the first thing. And, having a slight tantrum every time you get a ruling that you don't agree with is really not appropriate. And I'm going to ask you to consider that moving forward. The second thing is the state is correct, Mr. Cruz, in terms of the procedure to request to admit an inconsistent statement, and you have not done it properly. I will say for the record in this particular moment that your question was not the appropriate question to ask to recognize an inconsistent statement. It was kind of a trick question of sorts. You asked her to describe that particular piece of clothing, and her response was, I would say it was a hoodie, as if there was sort of the question allowed this witness, at least in my impression, to sort of pick.
And let me remind you, the witness is sitting there on the stand this whole time, listening to this.
Was it sort of a shirt or was it a hoodie? And the testimony, as I heard it, was that she elected to sort of describe it as a hoodie. If you would like to make an argument that in and of itself is what the law says is an inconsistent statement under the evidence code, then I will hear it. But if not, I'm going to sustain the objection. Move on, sir. You may be heard, yes. And then I'll talk about the mistrial in just a moment, but go ahead.
If the Honorable Court has the statute, just save me a little time. I'm pulling the statute now, if that's okay. But if you have it readily available.
Well, Mr. Cruz, I'm not going to advise you on the law. And I think you need to be here prepared to argue it.
No, I just said if you had a copy of the statute, I was just trying to save it on the course of time, but I'll pull it up now.
What a condescending bitch.
-6-613, prior statement of witnesses, the title of that section. Under subsection A, the law provides, in examining a witness concerning a prior statement made by the witness, whether written or not, the statement need not be shown nor its contents disclosed to the witness at the time. Provided, however, upon request, the same shall be shown or disclosed to opposing counsel. Your Honor, in this case, I went above and beyond. I actually chose to refresh her recollection as opposed to impeaching her when we were talking about her statement. She heard the entire statement. I told opposing counsel, this is what I have. They heard the entire statement. Subsection B provides, except as provided in Code Section 248806, extrinsic evidence of a prior inconsistent statement by a witness shall not be admissible unless, first, the witness is first afforded an opportunity to explain or deny the prior inconsistent statement, which we did. I said, Your Honor, this is a quote. I read the statement as a quote. She said it was a hoodie. I confronted her with the statement, gave her an opportunity. She still chose to say this was a hoodie. Second, and the opposite party is afforded an opportunity to interrogate the witness on the prior inconsistent statement. The state will have opportunity to examine her on the prior inconsistent statement.
Mr. Cruz, what is the statement you're saying is inconsistent with this witness's testimony?
Sure.
I think that's part of what the state was endeavoring to argue. So what is it?
So the written question that I asked, the individual that she saw walking, did she state he was wearing like an orange colored shirt? She said that he was wearing a hoodie.
Well, that wasn't the question you asked, Mr. Cruz. The question you asked gave her an option to sort of describe what she meant. And you said something to the effect of, was it like a hoodie or a shirt? And she opined it was like, I'll say a hoodie. I'm not sure that's an inconsistent statement, but I will let you question this witness again with specific questions if you would like to elicit the proper information for the court. I will let you question her right now out of the presence of the jury, and we can go from there.
Sure. In your prior statement in law enforcement, did you state he was wearing like an orange colored shirt, orange or red, something bright?
Yes.
We can bring the jury back in. That's it.
All right. And Mr. Cruz, I want to comment on your motion for mistrial.
Sure.
I'm going to deny that motion. The granting of a mistrial by the court is a very, of course, as you are well aware, extreme option. And it is done in very limited circumstances where the matters that have been presented in court are of such a prejudicial matter, such a prejudicial level that the defendant cannot receive a fair trial. And
Which is exactly what he said he is experiencing. So it no longer is up to, I mean, it's like if you asked a third uninterested party what they've thought, I think that you would find that they would agree with the defense attorney, that there's a lot of bias. She's not impartial. She's very prejudiced against the defendant. I mean, I think she maybe sustained Mr. Cruz's objections a handful of times throughout this whole trial. And she sustained the prosecution's objections every time. I think maybe 2, maybe 3 times she overruled the prosecution. Other than that, they were all sustained.
with regard to your motion, you have not sufficiently shown this court that that exists. And so I'm going to deny your motion.
How do you get a mistrial from a judge who is being accused of the reason for the mistrial? That's what I want to know. I mean, have you ever seen a judge say, okay, I'm declaring a mistrial because I'm not impartial, I'm biased, I'm prejudiced against your client. You're right. I'm handcuffing you and I'm not letting you try this case. So yes, I'm granting you a mistrial. I can guarantee that probably has never happened. If she granted his mistrial motion, she would be admitting to everything he is accusing her of. So I don't feel like it's fair to file a mistrial motion to the very judge that you're accusing of being the reason of the mistrial. I mean, that's absolutely insane to think that she would ever Granted.
All right. Can you bring the jury in, please? Thank you. Melton, you have an objection?
I do, Your Honor. Mr. Yalamanchili and I had talked in anticipation of us getting to this point over the weekend. But since
is
I
a
had made opening
contempt
statement,
You pull that microphone
charge,
towards
so
you. Thank
we don't need to see that one.
Admissible, and the method Mr. Cruz not to do it is
Knows about this. You know.
time today. Attorneys and arguments are not evidence.
Okay, so we saw that, the rest of that.
testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
And I just need to make sure that you're speaking loudly enough into that microphone so that we can hear you, okay?
Okay. Is that better?
Ma'am, could you state
What the fuck?
and spell your name for the record, please?
Yes, it's Ashley Hall, ASHLEY, HALL.
And where do you live, ma'am?
In Dicula.
I'm going to ask you about your relationship with the deceased in this case, Tara Baker. How did you meet Tara?
We were in the same sorority at Georgia College in Milledgeville, and then we ended up living together in the sorority house for a couple years. We both came to Georgia and ended up living together here as well.
Can you describe, in general terms, your friendship with Tara?
We were extremely close. Pretty much once we met, that was kind of came a little bit inseparable. And then when we both came here for I was doing my graduate studies and she was in law school, we were living together. Of course, you just didn't have as much time together, but we were still very close.
What kind of friend was she?
Wonderful friend, sweet person, always nice to everybody, always up for anything. Very Southern Belle, very someone that was very into her family. Like I felt like her siblings were my siblings by the time I knew everything about them, all about her mother, how wonderful she was. She knew my family pretty much about the same. She very black and white. She knew right and wrong. There was no gray with Tara. Like it was, this is what you're supposed to do. This is how you treat people. Person overall. And I know people say that about a lot of people, but she really.
All right. I'm going to send the jury out. If you'll have a moment.
Where would she go to make the breakfast?
Well, she'll go to the kitchen to make the breakfast, and then she'll probably sit on the sofa and eat it.
And at that time, after eating her breakfast, is that when she would go back?
Go back in her room and finish getting ready, yes.
You indicated that part of that included blow drying her.
Yes, she had a lot of really thick hair. And so she would have to usually sit on the floor because she would get tired of standing up. And we've lived together since my freshman year. So it was kind of a joke, her sitting down on the floor, flipping her head over, doing her hair all the time, so.
What time would she start her day?
Depending on the class, if she had an early class, she'd like a 9:30, probably 6:30, 7:30. She liked to get everything ready and then study for whatever classes she had that day.
So that was kind of start that routine?
Yes.
Depending on what time the first class was?
Yes.
In kind of the last months of her life, there were
Oh, yes. Yeah, like I said, Tara's very black and white. Like, we're not ones to share like maybe the little minute intimate, but we definitely knew what was going on in each other's lives. I mean, that was, and if something was happening with Chris, since she knew I knew him and our relationship was what it was, she would have told me.
Ashley, or Ms. Hall, I'm sorry.
Yes, sir.
I believe I have a motion, Your Honor.
All right. I'm going to send the jury out. If you'll have a moment in the jury room and don't discuss the case. Thank you.
Just making sure.
Yeah.
Sorry, I was muted. I was saying she just has this irritated look on her face every time defense attorney Mr. Cruz stands up and speaks, or speaks even sitting down, I should say. Anytime he speaks, she just looks so freaking irritated. It's so obvious. If the jury's sitting there, they see that face. So you think they're going to respect Mr. Cruz when the judge is treating him this way? I don't think so.
Y'all may be seated. You have a motion, Mr. Cruz?
Yes, ma'am, and I'd just like to put the basis on the record. As the Honorable Court is aware, Mr. Faust has restriction on his line of questioning that he could ask witnesses in regards to statements that Ms. Baker may have made to said witnesses. During the state's examination of Mrs. P.V. Hall, there's been intimations of, well, and I'll say what the exact statement was, that if something was going on, she would have told me. Well, we have evidence to the contrary, but as of right now, we can't confront that statement because of the Honorable Court's ruling. So before I move further with our motion, I would ask, would the Honorable Court reconsider its ruling in regards to our residual hearsay motion with the statements that we have that Ms. Baker shared through Ms. Ashley Peavy?
All right, thank you. Mr. Bolden, Mr. Yeoman, shall you care to respond to the motion?
It's asking the court to reconsider its ruling on our 607 before we move forward with any other motion. Our residual hearsay motion. I mean 807.
I mean, they have so little respect for Mr. Cruz that they don't even listen to his objection. So when the judge asks the prosecution if they have any response to Mr. Cruz's objection, they have to have Mr. Cruz restate his objection to them personally. They weren't listening. Total lack of respect. It's disgusting.
Excuse me.
Your Honor, to the extent that the state has asked Ms. Hall to testify about anything that Tara may have said, I understood the court's admonition the first time and have intentionally stayed away from that. I don't think that I have failed to, or I've elicited any testimony that would, violate the rule that requires notification. So I don't know exactly what Mr. Cruz is asking.
All right, thank you. So first of all, your request for a reconsideration of a prior ruling is not properly brought in this manner. That's not an objection. And I think you're misinterpreting my prior order. And so I think it would be imperative, Mr. Cruz, to go back and review what my orders were about. If you want to file a motion to reconsider, you certainly may do that, and I will consider whether it is timely and whether I should take it up. But I think your interpretation of the court's order is not accurate.
It is accurate, Your Honor. The order that you gave.
I'm not going to argue with you, Mr. Cruz. I have made my ruling.
Well, sure. Well,
Do you have any other objection before I bring the jury back?
I
What is your
moved for a
objection?
mistrial. And the grounds we're moving for a mistrial on, Ms. P.V. Hall was able to testify that Tara would tell me if there was anything going on with her and Chris Melton. we've submitted to the court and filed a residual hearsay notice to address those statements that were made. The Honorable Court advised us that we could not mention anything that Tara Baker told Ms. P.V. Hall in opening, and we cannot ask any questions related to that. Evidence has come into this case contrary to our 807 notice, residual hearsay notice, and we asked the Honorable Court to reconsider its restriction on the defense that is not on the state and allow us to ask questions in regards to that. The door has been open, Your Honor. We're just asking for fairness at this point.
Okay, Mr. Cruz, once again, you are misinterpreting this court's order.
I am not, Your Honor.
Mr. Cruz, I'm not going to argue with you.
Yes, ma'am.
I'm just going to tell you what the court's position is. You are misinterpreting this court's order.
No matter how big of a bitch she acts like to him, he's very respectful to her. And I don't know how he does it. I'd lose my shit. I could never be an attorney. Ever.
It would be helpful for you to go back and look at the order and to review the law.
It's not written.
Mr. Cruz, I'm talking now.
Yes, ma'am.
It would be very helpful for you to go back and look at the court's order and to review the law that the court used in coming to that decision. This is not grounds for a mistrial. I'm going to deny your motion for a mistrial. If you want to file a motion to reconsider and it is filed properly, I will consider whether it is appropriate for the court to hear it at this point. We will, of course, do it outside the presence of the jury if the court decides to hear it. But until that motion is filed, I'm not going to consider a motion for reconsideration in this forum. But I do think it is imperative for you, Mr. Cruz, based on your arguments, to go back and look at the court's order and the law and to interpret it properly. And that is going to be my final answer. Would you please bring the jury back? Thank you.
Can we ask her about it? That's what the court hasn't ruled on, Your Honor.
Mr. Cruz, it would be imperative for you to begin your cross-examination. If there's an objection, I'll rule on it.
Yes, ma'am.
She is such a raving bitch that, yeah. Let me see if I have some more that I can show you. It just goes on and on and on like this through the whole trial. And it's disgusting to watch. And I just can't even say any more about it because I'm repeating myself at this point. Let's play some of Christopher Melton's testimony. He loses it on the stand. You know, I mean, he literally, I thought he was gonna pass out or fake a pass out. I mean, I don't know that he was really that bad off or if he was playing it up for the jury. Mr. Cruz was hammering him with question after question that he couldn't answer, and his answers were very inconsistent with his interview with the detectives. Okay. Let's see what we got going on here. And I probably won't be able to play his whole testimony because it is pretty long. It takes the whole day, I believe. But we can get through some of the good stuff anyway.
Sir, if you would, please raise your right hand and take an oath. Do you swear or affirm testimony you'll give to the...
And that was how we had the interview. Okay. And
I'm going to stop you just a week.
Can you all confer about whether that's accurate since you're offering to stipulate?
Yeah, this is
Okay.
And the furnished basement was,
Did.
Thank you, Your Honor.
And you said that was what, Mr. Cruz? I'm sorry, 14.
1442 through 14. When you went to your parents' home the week before Miss Baker's death?
I don't recall the question.
Say that one more time. You don't recall what now?
I don't recall.
Being asked that question?
Yes, sir.
Okay. Do you recall making the statement? So I was working there and driving back and forth. Well, my parents, we had a furnished basement. So then that's where I was. Do you recall making that statement?
I don't recall making the statement, but it seems okay.
Judge, I move to introduce
I don't believe that was the photo.
Can you describe the photo that you were shown to identify Ms.
Oh, I wanted to show you the beginning of his cross-examination. It's pretty intense.
Maybe it was 10 days prior.
That is fair. So let's.
After I left Nashville,
Based on that, did you make your apartment at Jamestown?
that's correct.
Okay. How?
She was supportive of my pursuit in certain moments to recollect certain things. And sir.
Let me cut you off. So it's easier to recollect an alibi than it is to recollect.
Sorry.
We did have a place to meet, go. I could have crew leader, you're issued a vehicle, gas card, all your equipment, tools, fittings, and so forth. Whatever's needed to complete the job, they supply.
Okay. So who was paying for gas when you were working for McCart and living in Athens and having to travel for jobs?
When I was working for McCart, they paid for everything.
Was that the case for you as a subcontractor trying to go out on your own, or was?
Okay. I was within within a week I had started. What I had to make the decision was to stay at my parents' due to the cost we would have liked, but we were both in the understanding. After I left Nash Plumbing, I went to the bank.
Okay. Can you write the time that you arrived at the bank on the board? You can just put bank and then you can put the time.
That y'all talked about a future together?
Yes, sir.
Okay.
More difficult than others in certain moments to recollect certain things. And sir.
Let me cut you off. So it's easier to recollect an alibi than it is to recollect.
Anyway, when he first starts his cross-examination, the first question he asks Christopher Melton is, how come you're not crying? How come you didn't cry? And he said, when now? And he said, yeah, how come no tears fell? He said, well, they did. They didn't.
Whether or not the girl that you love told you that she was going to be home alone.
This question is argumentative and improper.
Sustained.
Sure. So it's easy to remember where you went on the 19th. Is that correct?
That is correct.
Okay. Mr. Melton, so after you left Nash Plumbing, where did you go?
After I left Nash Plumbing, I went to the bank.
Okay. Can you write the time that you arrived at the bank on the board? You can just put bank and then you can put the time. Sure. So just to ask you, so you can remember that you went to Nash Plumbing, and then after that, you can remember that you went to the bank from January 19, 2001.
That's correct.
But you cannot remember from January 18th whether or not Ms. Baker told you she was going to be alone?
At that time, it could depend on when the question's asked. It's not, if it's in a stressful moment, I'm going through things and trying to pull from times prior to this, when I'm not trying to, how should I say, lock in on certain things previous to this, it is difficult.
Would you agree?
Previous to to her death. Go ahead.
I didn't hear you. Say that one more time.
I should say, it's like certain days, if somebody asks you what you have for breakfast, I couldn't tell you. But if I'm concentrating on after certain times, yes, I can, on certain things. But it's hard to describe.
So I'll switch gears because I do want to talk about a difficult subject with you. You mentioned that you were told that your DNA was in Miss Baker's anus. Is that right?
Yes, there was a point in time.
Okay.
I found out.
And we've agreed that that time didn't occur during your recorded interview. Is that right?
I can't recall.
Fair. That is fair. So let me ask you this, Mr. Melton. You would agree that Ms. Baker did not engage in anal sex with you. Is that correct?
That's correct.
You would agree that Ms. Baker was sexually assaulted anally. Is that correct?
I wouldn't really know if she was sexually assaulted anally. Like, I don't.
Well, we can't have it both ways, Mr. Melton.
I don't understand the.
You previously stated that Ms. Baker, not Ms. Baker, I'm sorry, Ms. Bigham
I see.
and Jeremy Howell told you that your DNA was in her anus. Can we agree on that? Is that fair to say?
Maybe I'm mistaken on how I found that information out. Maybe.
I'm going to object to lack of personal knowledge. Mr. Cruz is asking this witness about information that was relayed to him as hearsay by other witnesses who had the actual information. So I think that's both lack of personal knowledge as well as calling for hearsay.
All right. Any response to the objection, Mr. Cruz?
Sure. Mr. Melton stated that he was aware that his DNA was found in Ms. Baker's anus. He stated that Ms. Bigham and Jeremy Howell were the individuals that told him, and we're fleshing out his knowledge in regards to what he's aware of, Your Honor.
I think as to the form of the question, I'm going to sustain the objection. You may rephrase.
Thank you, Your Honor. But there should be no reason that your DNA should be in Ms. Baker's anus. Would you agree?
I mean, other than if we have had sex and it has transferred from there and, say, drained down to that area. But
that is interesting that you say drain, because did you know that's the exact same thing the state is arguing in this case?
well, I mean, it makes sense, though.
So your DNA is in her anus because it drained down in her anus. Is that your position?
I would say that would.
Object again, Your Honor, lack of
I'm sorry, but not to be crass, but your anus is a sphincter and it closes off. And it's a one-way sphincter, so it closes off and opens to the outward direction for when you have a bowel movement. I'm not seeing how it can. I can see how it can maybe drain down there, but it can't drain in to her anus. Maybe on the outside, but not inside. I'm sorry.
personal knowledge, lack of foundation. There's been no foundation laid that Mr. Melton's aware of these things. That would all be through GBI crime lab witnesses who do have personal knowledge and scientific information. And so there's no foundation for these questions, and he's asking for things that are outside of Mr. Melton's personal knowledge. He's asking about things.
I would object to a speaking objection, Your Honor.
He heard this from the detectives themselves. How that is not reliable Well, I guess if it's not reliable, then you're saying that those detectives are not reliable, which leads one to think that this whole investigation is a shamble and not worth bringing to court.
And just ask the state to state the ground.
Okay, I'm going to overrule that objection. He was just explaining his objection. I'm going to respond in the same way as the last objection. I'm going to sustain the objection as to the form of the question, allow you to rephrase if you choose to do so.
Yes, ma'am. Thank you. Thank you, Your Honor. Exhibit 38 through defense exhibit 40.
I have 37 also.
I'm sorry, 37 through
Go ahead.
through 40. Please forgive me. Is it okay if I approach you, Mr. Melton?
Yes, yes, sir.
Please take a moment and take a look at defense.
And mind you, the detectives are sitting through this trial. They are allowed to sit behind the prosecution's table or behind the prosecutor through the whole trial. Even though they are going to testify at some point, they get to sit through everybody's testimony. That's, to me, that's just crazy. And he keeps looking over at somebody, and at one point, Mr. Cruz asks him, "Who are you looking at? Are you looking at them for help, or what's going on?"
Exhibit 37 through defense exhibit 40. You recognize defense exhibit 37 through defense exhibit 40 as the wall that you punched, is that correct?
I would say yes.
Okay. Is that a fair and accurate depiction of how that wall looked after you punched it?
I'd say from what I could recollect.
Sure. Has that photograph been altered in any way?
I'm not sure. I wouldn't.
Well, you have no reason to believe that photograph has been altered in any way, is that correct?
I have no reason to believe.
Your Honor, I would ask to admit defense exhibit 37 through defense exhibit 40 into evidence.
Any objection?
No objection.
They are admitted.
Thank you, Your Honor. I would ask to publish to the jury.
Granted.
Now let's talk about the injuries to your hands, Mr. Melton.
Yes, sir.
Court's indulgence.
Come on.
And the photographs of your hands have already been admitted through, as defense exhibit 29, collectively. Your Honor, I just asked to republish the photographs of the hands to the jury.
Granted.
They better not blur this out.
Court's indulgence, Your Honor. I need one of these photographs. Mr. Melton, I am going to show you one of the photos from defense exhibit 29, and we're going to talk about some of these injuries.
It looks like they're going to blur the photo of his hands out, which is going to piss me off.
All right, can you see your hands on the screen, Mr. Melton?
Yes, sir.
Okay, and you would agree, for the purposes of the record, I am making a fist. Mr. Melton, you would agree that a fist looks like this, is that correct?
Yes, sir.
Okay, can you make a fist and show the jury what your fist looks like? Okay, excellent. I want to talk about this injury here on the side of your thumb. Can you explain how you got that injury from punching drywall?
My hands are from work.
Are they?
I mean, no, I'm saying my hands from work are naturally have nicks and such on them, but that very well could have occurred. I mean, from punching through a wall, there's also things inside the wall. There's siding on the wall that has, once you go through, there's nails that may have been there. But at that point, I mean, I have little nicks and cuts just from my profession.
But Mr. Melton, isn't it fair to say as a plumber you wear gloves?
No, sir.
You never wear gloves?
I wear gloves, but not 100% of the time. No, sir.
Well, I showed you Defense Exhibit 37 through Defense Exhibit 40. There's a pair of gloves hanging on your wall, Mr. Melton.
Hanging on my wall.
But you don't use them.
When you're working with your hands, you work quickly also. And you don't have time to always have gloves on. And at that point in time, I'm not working with raw sewage or anything. This is new materials. So with that being said, you not worried about bacteria or anything infecting your hands. You just work through it.
So today, on February 9th, 2026, you remember exactly how you were working on January 19, 2001.
It's easily to assess because I worked it for so long.
Sure, but you don't remember whether or not Ms. Baker told you she was going to be home alone the day before her death.
You know, in moments under stress, I can't recall everything.
So let me ask you about this injury here. So did this come from the wall or did that come from work?
Is that an injury?
Right here.
I don't know if I...
Or how about this injury here, Mr. Melton? How would you get this injury on the top of your hand going in this direction from punching sheetrock?
That even appears... Oh yes, even when you punch through walls, you got to pull your hand back. I'm punching into a wall, pulling my hand back, punching through a wall, and even at work, I have nicks, cuts, and even burns from soldering pipes and hot materials. I can't tell if that's an injury from hitting something or an injury from work, and it may look like looks like it could be even a slight solder. It's hard to say. I mean, it's hard for me to assess that.
But this is the first time in 25 years that you've ever made the statement that these injuries were from work. Would you agree?
I've never been asked the question as far as if they're from...
And just to make sure we're on
that I can recall.
Just to make sure we're on the same page, your exact statement was to law enforcement is the injuries. Matter of fact, we don't even have to go to law enforcement. Your exact statement in the court before these jurors was that these injuries came from punching the wall in your apartment. Do you recall making that statement?
Was this prior to being shown pictures?
Mr. Melton, do you recall making that statement?
Yes, I had injuries from my hands from hitting the wall. That's what I recall.
But when I asked you about the injuries, you are now saying that they are from plumbing and hitting the wall. Is that right?
Well, when you're pointing out specific things, like I do have from plumbing, you're going to have nicks and cuts or whatnot from that.
My question is, during my examination of you, this is your first time saying that these injuries are from plumbing. That's a yes or no question, if you can.
Since you just asked that question, I guess I would have to say yes. And
once the jurors finish looking at the photos, we'll go over some other photos as well. Now, on the day of Tyra's death, you voluntarily went to the Athens-Clarke County Police Department.
That's correct.
Okay. And I believe the state asked you a couple of times, did you hire a lawyer or did you refuse to speak to him? When you agree as the boyfriend, if you refuse to speak to him, you would look even more guilty?
Restate the question.
Sure. The state asked you on direct examination multiple times about whether or not you got a lawyer or whether or not you refused to talk to him. Do you recall being asked that question?
Yes.
Okay. When you agree as Ms. Baker's boyfriend, you would look more suspicious if you refused to talk to law enforcement.
If I refused.
Okay.
Yeah, okay.
So we agree on that. Is that right?
Of course. I mean, I'm always wanting to be cooperative.
Sure. But that was a yes to my question, right?
Yes.
Okay. You would also agree you would look more suspicious if you refused to give blood. Is that correct?
Correct.
Okay. You would look more suspicious if you refused to give hair. Is that right?
Correct.
You would look suspicious if you refused to talk to him. Is that correct?
Correct.
Now, you conducted an interview with Officer Bill Ricketts on the 19th. Do you recall that interview?
I believe so.
Now, you state you believe so. Are you certain that you remember conducting?
Yes, I remember an interview on the 19th.
And your father was present with you during that interview. Is that correct?
Yes.
Okay. And he sat with you for the entire interview.
Yes.
Okay. And during that interview is when you told law enforcement that you were at your parents' home at 7:15 on January 19th. Is that correct?
Yes.
Do you recall during the interview being asked how would you describe you and Ms. Baker's relationship?
Yes.
And your response was that she was your borderline fiance.
I recollect.
Okay. And you advised him that you and Ms. Baker.
I have never heard that term before. Borderline fiance. What the hell does that mean? Is that something new?
Baker were very serious at the time of her death.
Yes.
And I believe you established with the state that the truck you used for work at the time of Ms. Baker's death was your own work truck, the truck you purchased. Is that right?
Correct.
Now let's talk about Josh McCourty. The state asked you about it with Josh, and you stated that he was just a coworker that you met at McCarthy.
Fair.
So at some point you leave truck customs, is that correct?
That's correct.
And I'm sorry, Mr. Melton, do you still have that marker I gave you?
Yes, then I had failed to mention that I went by the bank that morning. Yes.
And you stated that you were in the bank for a total of 35 minutes, is that right?
Sounds about right.
Okay. Next to bank, can you put 35 MIN and circle it?
I had been informed that day.
Now, law enforcement also informed you of that. Do you recall?
I don't recall.
Would hearing the recording refresh your recollection?
I would say if I heard it, it would help reflect.
There, they take it to store it, put in evidence, and then on Monday morning, we've got a good working relationship. They'll start right away for us and tell us exactly what we've got.
Draped across her. is at the bottom frame of the digital image.
All right, so I asked you this question. Do you remember telling law enforcement that the photo shown of you, of Ms. Baker, had a blanket covering her from the neck down? So I saw her face and her hair.
Correct.
And the photo I showed you was a photo of Ms. Baker with a sheet covering her from the face down, the neck down, and you saw her face and her hair. Is that right?
Correct.
Okay,
Correct.
But we can agree you did not see a black cord wrapped around Ms. Baker's neck. Is that fair to say?
That's fair to say.
Do you recall a police officer interviewing you about you telling Mrs. Virginia Baker that you saw a black cord wrapped around Ms. Baker's neck?
Not a black cord wrapped around her neck, no. I don't recall that.
You don't recall?
I do recall in the original photo that I saw, there was something draped over her, and I could recall seeing something black. I didn't know what it was. But like I say, I don't think that's even the image I saw.
So, Mr. Melton, we're speaking, the specific question I'm asking you, and you might have answered, I just want to make sure I'm clear. In the photograph you saw of Ms. Baker, it was her with a sheet from the neck down. Do we agree on that?
The one you showed me, yes.
Okay, not the one I showed you, the one you described to law enforcement.
I believe I stated there was something from, I don't know if I said sheet, but in the digital camera at the bottom section of the frame, it kind of stopped. But you could kind of see something laying there.
Sure, Your Honor. Mark, I move to Mark.
He's slowly starting to lose his composure, and it's very interesting to watch. If you haven't seen this trial, I suggest you definitely go back and watch it from the beginning. If you don't want to watch the whole trial, at least watch Christopher Melton, this man. Watch his whole testimony. It's Mr. Cruz does an excellent job breaking him down, and he falls all over his lies. He can't keep anything straight, and he ends up admitting to pretty much everything Mr. Cruz is saying, and it's crazy to watch it play out.
Move to mark the audio recording of Chris Melton with Detective Newton as Defense Exhibit 42.
Mr. Cruz.
Yes, sir. Now, at this concert that you went with Miss Sherling, that you went with Miss Sherling to, there was a total of 6 people. Is that correct?
Sounds accurate.
Okay. It was Miss Sherling's mother and father.
Instead of going to his borderline fiance's candlelight vigil, he went to a country concert with one of her good friends, supposedly, and 2 other couples. So my question is, why wasn't her friend at the candlelight vigil? I mean, he obviously should have been, but why wasn't the friend? I mean...
Is that right?
Yes, sir.
Okay. It was her neighbors, which was a guy and a girl couple. You haven't heard what's on this flash drive, have you?
On the flash drive?
Right. You haven't heard what's on this flash drive, correct?
I don't know what's on your flash drive.
Let me ask you this. Did the state play your interviews for you?
I have heard the interviews.
They've played them for you?
I have heard the interviews.
Okay. So you're familiar with your interviews with law enforcement, is that correct?
That's correct.
Okay. And you are familiar with the interview that took place where you discussed with law enforcement the incident that took place the week before her death. Is that right?
Yes, I'm familiar with that question.
Okay, and the reason you're familiar with it is because you've heard the interview, correct?
Well, I'm familiar with the question from originally, plus after 25 years, I think it's fair to say that I need to hear what I said on recording.
So you'll like to hear it to determine if it's a fair and accurate rendition of your statements to law enforcement on June 20th, 2001?
I would like to hear to see if it's accurately depicting your question, because you say, did I state, and in my explanation, that it actually happened the week before. The question he asked was, did it happen? He goes, what happened, or was there anything the week before that could have jeopardized your relationship? And then I go into an explanation of something that was always on the forefront of my mind because I hurt her feelings, and it did not happen the week before. But I did not explain to them it did not happen the week before. I just went into an explanation of something that I was recollecting.
Okay, I'm going to allow you to hear what's on this flash drive, Defense Exhibit 43. Do we have headphones? Do we have headphones? We don't have headphones. Your Honor, I would ask, and I apologize to everybody, I would ask that I have the opportunity to lay the proper foundation for this flash drive with Mr. Melton outside the presence of the jury.
All right, we will do that. Ladies and gentlemen, if you'll go into the jury room, don't discuss the case. We'll be with you shortly. You all may be seated.
This is the detective that worked sex crimes. She's a whole different kind of animal. She's just...
So, Mr. Cruz, let me just make sure for the record, you are you trying to refresh this witness's record?
No, I am not. I am laying the foundation for impeachment. I just want to lay the foundation that he recognizes this this exhibit. I think that's the only piece that's missing.
So are you trying to lay the foundation for a prior inconsistent statement?
Correct.
Okay, all right. Go ahead.
May I, Your Honor?
You may.
Okay, thank you. Let the record reflect that I'm playing for Mr. Melton. Minute mark 6:13 through minute mark 6:49 for the purpose of laying the foundation for this audio recording.
Anybody now? Even if another thing was issue, we'll call it an issue until we hear from you, was brought up to us. Something to the effect that like a week prior to Tara's death, Tara had found out some information could have maybe jeopardized y'all's relationship. Do you remember having a discussion? I think
something that she might have found at your apartment in Athens.
I think she went there to leave you a note or something.
Yeah, I know it was.
Okay. How about?
Did you have an opportunity to hear that, Mr. Melton?
Yes, it did.
Okay. Is that you on the audio recording?
Yes, it is.
Okay. Is the minute 6 minutes and 13 seconds to 6 minutes and 49 seconds? Is that an accurate? Is that an accurate portion of your conversation with law enforcement?
Yes.
Okay. You recognize this audio recording as the conversation you had with law enforcement on June 20th, 2001. Is that fair?
Yes.
Okay. Does it sound like it's been altered in any way?
No.
Your Honor, I believe the proper foundation has been laid for the audio recording. I'd ask that the jury be allowed to come back in.
All right. Thank you. Mr. Yelmichili, do you have an objection?
I think at this point, the foundation has been laid. However, I did not hear a prior inconsistent statement. It's exactly what Mr. Melton said, which is that he got asked the question and then he launched into an explanation of what happened without correcting the date. So there may be something beyond this that Mr. Cruz wants to play that shows the inconsistency, but I believe, as far as what I heard, Judge, it was exactly what Mr. Melton testified to, which is that, yes, in response to that question about a date certain, I started to launch into an explanation about the only incident that I could think of, but it is not actually from that date, and I didn't clarify that for law enforcement, which seems to be what happens on the recording, but obviously the court heard the recording as well and can draw its own conclusions.
Mr. Cruz, any response to Yelmichili's comments?
Absolutely. That's a misrepresentation. Law enforcement clearly asked him if he was aware of an incident that occurred the week before Tara's death, and Mr. Melton, before I cut the recording off, said, yes, I'm aware of that incident. My specific question to him was, Mr. Melton, was there incident? Well, my specific question to Mr. Melton was, Chris, the week before Tara died, there was an incident that upset her and jeopardized your relationship with her. Do you remember that? His first answer was no. It was months ago that it happened. And eventually we got to him saying, well, I just told law enforcement that it was. I confronted him with the statement, Your Honor, I would ask that I'm allowed to impeach Mr. Melton with a prior inconsistent statement, because Mr. Melton danced around the answer. He wouldn't give me a clean yes or no.
I'm going to ask you to play it again because I did not hear what you're articulating.
Yes,
so
ma'am.
I'd like to hear it again, please.
Yes, ma'am.
Thank you.
Another thing was issue, kind of, we'll call it an issue until we hear from you, was brought up to us. Something to the effect that like a week prior to Tara's death, Tara had found out some information that upset her and could have maybe jeopardized y'all's relationship. Do you remember having a discussion?
All right, thank you. That's what I thought I heard. So I think that we are at a moment of the interpretation of semantics.
Sure.
But I do think semantics matter in this moment. And what the officer just said, which is why I needed you to repeat it, was that something happened the week before where Ms. Baker had learned of something. Mm-hmm. And that is a different set of words and a phrase than what you're asking Mr. Melton. And so based on that recording and based on the questions that you are asking Mr. Melton, that's not a prior inconsistent statement. You certainly may continue questioning him, but that does not qualify as a prior inconsistent statement. If there's more context, for example, in that recording that supports the way that you have asked the question, we certainly can get into that. But this particular thread that you have played very specifically says when she learned of something, and that is different than what you've asked.
Yes, ma'am. That's fair. We could bring the jury out. I've played it. He's laid the foundation for the recording. I'll ask the appropriate question, and depending on his response, we'll take the next steps.
All right. You may bring the jury out. Thank you. Y'all may be seated. Thank you. Mr. Cruz?
Yes, ma'am. Thank you, Your Honor. Mr. Melton, do you recall law enforcement asking you that like a week prior to Tara's death, Tara had found out some information that upset her, and could have maybe jeopardized your relationship. Do you remember having that discussion? Is that
Yes,
accurate?
they asked that question.
Sir?
Yes.
And you were told, I think she went there to leave you a note or something. Do you recall that?
I recall them saying yes.
Okay. And your response was, yeah, I know what it was.
Yes.
You'd agree that you never disclosed that information to law enforcement until you were asked about it 5 months after her death. Is that correct?
That's correct.
You never shared with law enforcement the issue that led to Miss Baker not spending Christmas of 2000 with you, did you? Or Christmas Eve. Let me use the right date. Christmas Eve of 2000 with you. Is that correct?
I believe we were together Christmas Eve.
Your testimony here today is that you and Miss Baker were together on Christmas Eve?
Portion of the day, I believe so.
You never shared with law enforcement the reason why Miss Baker did not spend New Year's with you, did you?
Tara did spend New Year's. She spent New Year's Eve with me into New Year's Day. Yes.
You never shared with law enforcement the reason Miss Baker stopped calling you the week of December 27th to January 3rd, despite being home. Is that correct?
What were the dates you just said?
December 27th to January 3rd, 2001.
I don't recall.
You never shared with law enforcement that Miss Baker told you that she needed space to focus on her studies 2 weeks before she died, did you?
Are you asking me? I'm sorry.
Sure.
There's a lot of questions.
You would agree that you never shared with law enforcement that Miss Baker told you that she needed space to focus on her studies 2 weeks before her death.
I'd agree.
And you also never shared with law enforcement that the day before Tara was murdered, that was the most that you two had spoken in the previous 2 months.
I don't know about that now. No, as far as did I say, I'm sorry, repeat your question. I'll make sure I understand you correctly.
You would agree that you never shared with law enforcement that the day before Miss Baker was murdered, that was the most that you two had spoken in the previous 2 months over the phone. I left that portion out, so please forgive me. Over the phone.
Okay. No, I don't believe I discussed that with the police. I wasn't really aware.
Would you have any reason to disagree that before Miss Baker died, others believed that it was clear that your relationship with Miss Baker was over?
It wouldn't be apparent or aware to me, no.
Let's discuss your dating history with Miss Baker. Is that fair?
Fair.
Okay. When you met Miss Baker, you two were in Milledgeville. Is that right?
Correct.
You two were.
Sunday, it's just.
That's a yes to my question? Regards to the 10-day window, you would agree that when law enforcement met with you, you told law enforcement in 2024 that you were certain it had been 10 days since you last saw Miss Baker. Would you agree with that?
I stated that in confusion, yes, sir.
Okay. But you stated it. It was in confusion, but you stated it.
I stated it.
Okay. And Miss Elizabeth Bigham told you that she had your DNA. Is that right?
At some point, yes.
And she told you that because of the DNA that she had of yours, it could not have been 10 days. Is that correct?
Correct.
Okay. Ms. Bigham also told you that they need to be able to explain away your DNA. Is that right?
Correct.
And in response to let me ask this question the right way. In response to Ms. Bigham telling you that she needed to explain away your DNA, you continued to tell her that, no, I'm certain it's 10 days since I last saw Ms. Baker. Is that right?
I started reflecting, and I do recall being with Tara the weekend before. I have always stated from prior to that I was with her the weekend before. Time had gone by, and confusion had started setting in, and I was reflecting on the last time I had stayed in Athens. But indeed, Tara had come to my house that weekend.
But you didn't say that you had seen her that weekend until Ms. Bigham told you that You said that you saw her that weekend back in 2001. Is that right?
That's correct. And other times beyond. Yes, sir.
And Miss Bigham told you that your DNA was found in Miss Baker's mouth. Is that correct?
That's correct.
And she told you the DNA doesn't last that long in her mouth. Is that right?
Correct.
And she told you all of this information before you said that, hey, I remember now, I saw Miss Baker the weekend before she passed away. Would you agree with that?
Correct, I would say.
But one thing that you were adamant about with Miss Bigham that she couldn't get you to change, you said, I did not see Tara Baker the week of her death. Is that right?
That's correct.
Okay, so I want to make sure we're clear for the record. You didn't see Miss Baker on Monday. Is that right?
Correct.
It's undisputed that you didn't see Miss Baker on Tuesday. Is that correct?
Correct.
It's undisputed that you didn't see Miss Baker on Wednesday. Is that correct?
That's correct.
And it's undisputed that you didn't see Miss Baker on Thursday.
Correct.
And it's undisputed that you didn't see Miss Baker, you would say you didn't see Miss Baker on Friday.
I think it's undisputed.
So we have Friday, Thursday, Wednesday, Tuesday, Monday. So we'll say at least 5 days, right?
Correct.
Okay. And you told Miss Bigham that the closest time, for the first time, that you believe you saw Miss Baker last or had sexual intercourse with Miss Baker last was the Sunday before she left. Is that right?
Sounds accurate, yes.
Okay. And that was the first time in 24 years that you ever told law enforcement that you had sexual relations with Miss Baker on Sunday.
I think in the past I'd said it in the weekend, and I had said we had sex on Saturday, and then I'm sure that I believe that we had sex on Sunday. It's just, yes.
That's a yes to my question?
I would say yes.
So if you're, I won't ask that question. So at the time of Miss Baker's death, you stated today, I believe, that you and Tara, well, I'll ask you, how long had you and Tara been dating at the time of her death?
Again, that would be 2.5 years.
Not 3.5 years?
2.5 years.
Not 3.5 years?
From 2.5 to, I think our 2-year anniversary was the July 4th prior. I believe that we considered us actually a couple.
Okay.
Yes.
So we'll say 2.5 years. So in 2 years, 2.5 years, within that 2-year window, you moved to Athens to be near her. We've agreed on that. Is that right?
Correct.
You helped her move into her Deer Park apartment. Is that correct?
Correct.
And at the time she moved into her Deer Park apartment, is it fair to say that you two were in a serious relationship?
Correct.
But Ms. Baker didn't choose to move in an apartment with you. Is that correct?
That is correct.
The day before Ms. Baker died, you would agree that you two spoke 5 times.
Sounds right.
And we've agreed for the past 20 years, you've stated court's indulgence. Now, Mr. Melton, we've already agreed that in 2001, you were advised that Ms. Baker was sexually assaulted. Is that correct?
That's correct.
Okay, you heard it, you testified to it. Is that right?
Correct.
Okay, now you do recall also meeting with GBI again on May 5th, 2024. Is that right?
That's correct.
And during the May 5th, 2024 interview, you were told that someone else's DNA was found in Ms. Baker's mouth. Do you remember that?
That's correct.
Okay, and is it, you were told that it was the bad guy's DNA. Is that right?
That's correct.
You were also told by law enforcement that they did not intend to arrest you. Is that correct?
That's correct.
And they told you that they needed your help explaining away your DNA. Is that right?
They were trying to have an understanding of why the DNA was in their mouth, or was in Tara's mouth. So, ask your question again.
Sure. They told you they needed you to explain. They needed to be able to. Let me rephrase it. They were asking you to help them explain away your DNA or why your DNA would be present in her mouth.
Yes.
Now, when they told you that there was another DNA profile in Ms. Baker's mouth, your response is,
Can we approach, please?
You may.
is only giving me
I'm sorry.
authority to ask
Didn't
questions.
Didn't mean to look that direction. I apologize.
But the question I have for you. All right, so we've agreed that you were aware that Miss Baker was sexually assaulted in 2001, right?
Correct.
Okay. And despite this knowledge of her being sexually assaulted at the time of her death, your response was, I'm kind of stunned. I'm hearing there's two people, me and somebody else.
There's further description of that. I think they say in her mouth. Yes.
Okay. You make that statement.
And when they said in her mouth, yes.
Would it be shocking that if someone was sexually assaulted by someone else, that they would likely have more than one DNA profile in them? Is that fair to say?
Judge, I'm going to object for calls for speculation.
I'm going to sustain that objection.
In your personal knowledge, okay, if someone, whether by choice or not, is intimate with two people, you would expect that two people would be present. Is that fair?
If somebody was sexually assaulted, and I'm thinking that if it's in the vagina and around, yes.
No. If it's in the vagina and what? Please finish your statement.
Right. What question was asked? Well, actually, how can I have full explanation of the thoughts that are going through my head at that moment?
If I can ask you this, can you answer my question first and you can explain anything you need to explain?
Fair enough.
Is that fair?
Just restate your question, please.
So I think we agreed on the point that you said you were kind of stunned. I'm hearing that it's two people. We've agreed on that, right?
Yes.
And my follow-up question was, based on your personal knowledge, if someone is sexually assaulted by someone other than yourself, you would expect two people to be present. Is that right?
I would say yes, but I do have further explanation of my statement.
Sure. You were asked about your sexual history with Ms. Baker. Is that correct?
When can I continue? When can I continue to?
So I can't answer questions. The Honorable Court has only given me authority to ask questions.
Didn't mean to look that direction. I apologize.
But the question I have for you, you have previously described your sexual relationship with Ms. Baker. Is that correct?
Yes.
Okay. And that did not include anal intercourse.
That's correct.
And when investigators interviewed you on May 5th, you understood the importance of being truthful. Is that right?
That's correct.
And you understood, and you told them that you and Ms. Baker never, ever engaged in anal sex. Is that right?
That's correct.
Okay. And just a couple of more questions for you, Mr. Melton. I thank you so much for your patience. During direct examination, you talked about items on your hands. I believe you said it was plumber cement, it was solvent. What were the items that were on your hands when you met with police?
When do I get to go back and talk to about the other? refer to the previous question that you had.
So the Honorable Court has only given me authority to ask questions. After this hearing, you and I can discuss it if you would like.
And I not have an explanation to an answer. If I'm not, do I have the opportunity to explain a statement? If I'm not, I'm assuming I'm granted that. I'm not sure about.
The reason why he says, I assume I'm granted the opportunity to explain, is because numerous times during his testimony, he would try to elaborate on his answers. And Mr. Cruz would, say to him, excuse me, Mr. Melton, just my question is a yes or no question. Just answer yes or no. And he would try to explain or elaborate some more. And Mr. Cruz would repeat himself and say, it's a yes or no question. Just give me a yes or no answer. And the prosecution objected and said that the witness has a right to elaborate on his answer. And the judge agreed with the prosecution, and she allowed him to elaborate and go on and on and on to explain his answer. That happened 2 or 3 times, and that's why. And he was in there the whole time they were discussing these objections, because remember, I told you that the judge allows the witnesses to stay in the courtroom while they're making their arguments over these objections. So the witnesses hear what the prosecution wants them to say, and they alter their testimony to fit what the prosecution is asking. I just noticed that my frickin' banner's wrong, right? Is it? Oh my God. I'm sorry. Wow, how embarrassing. Okay, well, it's too late to do anything about that now. But anyway, she said on numerous occasions over a few, numerous objections by Mr. Cruz that he can elaborate. And so now he's got this cocky attitude that I assume I'm going to be able to explain my answer, and so he just goes ahead and does it because he knows that the judge is going to say, yes, you can. And I don't agree with that. I've never seen a witness be able to go on and on and on with their answer when it's a yes or no question. The defense attorney usually objects during the middle of their story or their explanation, and the judge usually turns to the witness and says, please answer yes or no. And then you may have the opportunity to elaborate or explain yourself on redirect when the prosecution redirects you. But for now, just answer yes or no. But this judge obviously, doesn't do that. She overrules Mr. Cruz's objections. Just a little bit longer.
The order of the questions that he's stating that Liz and Jeremy had asked me, the order, okay?
Objection.
And he calls them Liz and Jeremy instead of Detective so-and-so, which is just beyond.
Non-responsive to any question that I asked. No question about the order of questioning by investigators.
Well, the reason...
Right, hang on just a second. What was your question again, Mr. Cruz?
I believe the question, and Mr. Melton can correct me if I'm wrong, that he would like to follow up on was the question in regards to his statement, I'm kind of stunned. I'm hearing there's 2 people, me and somebody else. And I believe he mentioned about it being in her mouth. And I think he wanted to follow up on that, Your Honor.
All right, well, witnesses are allowed to explain their answers if they answer yes or no. Did you...
Look at the look on Chris Melton's face when she says that. I mean, what a prick. And for her to say it in front of him is just unexcusable.
Well, witnesses are allowed to explain their answers if they answer yes or no. Did you... why don't you ask that question again and see if you get the yes or no question, and if this witness would like to explain his answer, he may do so.
Sure, absolutely. And despite knowing that Ms. Baker was sexually assaulted for 23 years, when you were told that somebody else's DNA was found in her body, your response was, I'm kind of stunned. I'm hearing there's two people, me and somebody else. Is that correct?
Correct. Okay. With the explanation. When Liz, they tell me, not that it's in her body, they tell me specifically that it's in her mouth. Okay? In my mind at that point, I'm not accurate about DNA and so forth, timing and so forth, but there was just a short fraction moment of a time, and if I can request to even play that section of the audio, that for just a moment, I was taking consideration that was this voluntary? Because why in the world would she not bite his penis? If somebody's trying to do that, why would you not bite his penis? And that's what I...
And if you're her boyfriend or borderline fiance, how would this be your first thought when the police are telling you that there's somebody else's DNA in her mouth?
I was expressing. And I was in shock that it was in her mouth, because for just a fraction of a moment, it kind of went through my head. I was like, was something happening there that I was unaware of with Tara? And I'm ashamed to even think that for a second. And then Liz responds, don't let your head go there.
I'm ashamed to think that for even a second because he's black. Is that where we're going with that?
Objection, hearsay.
It's on the audio recording.
And then Liz, the detective, says, don't even let your head go there. Gotta wonder what they mean by that.
Rejection. That objection.
That's sustained, Mr. Melton, so you can't mention what anybody else said. I would like to follow up on this.
Okay.
If I could
Yeah.
on the hearsay objection, Mr. Cruz in this line of questioning has specifically mentioned the words that the GBI agents are saying back and forth to Mr. Melton. So I think as it relates to the rule of completeness in this line of questioning, Mr. Melton is allowed to talk about that because of the fact that Mr. Cruz has opened the door to it in his line of questioning.
But when the prosecution opened the door on that roommate's testimony, Mr. Cruz was not allowed to ask further questions in regards to that. But here, the prosecution is saying that Mr. Cruz opened the door to this testimony, and so he should be allowed to elaborate, and she's going to allow it. And you're telling me that she's fair?
On to the objection about the rule of completeness.
I would. So the purpose of my questioning was the effect on the listener. So it wouldn't apply as hearsay because they give them information or they make a statement to him. The most important portion of it isn't what's said to him. We aren't offering that for the truth of the matter. We're offering it to the jury for his response. So anytime that I've mentioned something from GBI, it's either been a question that was asked, which is not hearsay because it's not a statement offered for the truth, it's a question, or two, the objective effect on Mr. Melton in regards to how did he respond to that information. The rule of completeness, from what I understand, applies to documents, videos, things that if you only play a portion of it or show a portion of it, it wouldn't put it into context. Now, if the state would like to, well, I won't get into that, but that's my understanding of the rule of completeness. Right now, we're just going through his testimony with non-hearsay statements from law enforcement.
Okay, I'm going to withdraw my former comment that it is hearsay. Both parties have agreed that it is not hearsay. I'm going to allow you to complete your statement. Go ahead.
Wow.
All right, back to what I was saying.
Your Honor, I didn't agree that his statement wasn't hearsay. His statement was hearsay as far as what Ms. Bigham said. I was explaining my statements.
Well, I'm going to allow him to say
Yes, ma'am.
however you characterize it. I'm going to make a finding that both parties have said it's not hearsay. I'm going to allow you to continue explaining if you choose to do so.
Yes, ma'am. I'd like to continue.
Oh my God, she just
There was a
makes my
moment
blood
when
boil.
I'm going to have to back up just a touch, I guess, but I hear that there's semen in her mouth. I'm expecting it in other places of her body, but in her mouth, I was like, how did she not bite this person? And for just a moment, I was like, was this voluntary? And then I was going the wrong.
I'd be like, sir, can you please pull down your pants? Do you have bite scars on your penis?
Thoughts in my head, and Liz picked up on that also, and she stated something that was beyond my realm of consideration, and she says, that's
Not
if
Detective
Tara was
Bigham,
still
it's
alive.
Liz. Not even Elizabeth, it's Liz.
You were in her
Just
mouth
crazy.
too, is that correct?
It's the DNA, you're saying, yes, the DNA was located.
Okay.
Did it
That's
drain
what I've
from
been
her
told.
mouth?
And I just want to make it very clear for the jury. When you met with law enforcement on May 4th, 2020, May 5th, excuse me, 2024, you understood that your DNA was in Miss Baker's mouth.
That's what I was told.
Last question I have for you. I want to talk about your hands a little bit. Did you state you punched the wall 30 times?
I stated that I couldn't remember how many times I'd punched it, but I was just guesstimating.
Okay. But you stated that you punched it so hard that shingles were falling off the house?
No, that I was hitting at some point when I came through, I know I hit the siding.
Okay. Did you mention that you were hitting concrete and things of that nature?
Sir?
Did you mention that you hit concrete? Did I hear
Well,
that?
that's what the siding was made of.
Okay, so you were punching through the wall and hitting concrete.
Yes. And I remember I remember punching through and feeling the other side. Yes.
Okay. You would agree that you never told law enforcement that you sought medical treatment for your hands. Is that correct?
That's correct. I never did.
Okay. And you would also agree that you didn't break any bones in your hands. Is that correct?
That's correct.
Okay. You also agree that the injuries to your hand were scratch-like injuries. Is that right?
There were scratch-like injuries on my hand. Yes.
I think we established this. This is my last point. And I believe we've already talked about this and we've agreed on it maybe multiple times. But your hands were covered in work supplies when you went to meet with law enforcement, right?
Yes, I believe there was primer and maybe some glue that was on my hands.
You also mentioned cement as well, plumber cement, I think you stated.
Plumbing cement, it's a possibility. I wasn't completely accurate of all this, but it's primer I know that sticks to your hands, and then there's probably little pieces of adhesive.
Okay, and I want to ask you something that's very interesting to me, and this is my last question for real.
Mm-hmm.
You refer to the officers by their first names. How many times have you met with them before this trial took place?
That's how they always introduce themselves.
My question is, how many times did you meet with them before this trial?
Before this trial?
Hmm?
When they interviewed me?
Okay. How many times?
I think I've had a total of 5, 6 interviews.
As well?
As far as with the prosecutors, maybe 2.
Okay, so they've met with you a total of 7 times, but they told you that your DNA was present in Ms. Baker's dead body. Is that right?
You talking about Liz and
Correct.
Jeremy?
Correct.
When they interviewed me?
Correct.
They said my DNA was also there. Yes.
Thank you, Mr. Melton. I have no other questions for you.
Any redirect?
So, yeah, you just have to watch it. I mean, it's crazy, the shit that was allowed in, and I can't emphasize enough the craziness that judge caused in that courtroom because of her decisions and her rulings, and it was undescribable, if that's a word. I'm going to see if I can find a picture of his hands real fast. I know YouTube doesn't like this shit, this kind of stuff, but I'm a new channel, so I'm hoping that they won't mind, or they won't even hear about it because there's so little people that watch my videos. So we'll just hope. Chris Melton. And then we are done. I don't know what I changed some setting on my computer, and now every time I search for something, it says, do I want it translated in English? And if I just X out of that, everything's in German. So I'm not really sure what I did, but I fucked something up. And I can't figure out how to fix it. Because I went into my settings and it says everything's English. The settings are on English. So I don't know why it's asking me to translate everything. But if I don't translate it, it comes up in German, oddly enough. It would help if I spelled that right. Let me see. Can't. They're really making it hard to find a picture of his hands now. All of a sudden. That's odd. And the fact that they were blurred out in the video, that's crazy to me. Because in the live trial coverage, they showed it. They showed the picture up on the screen. Now I can't find a picture to save my life. That's insane. Nope, I don't think I'm going to be able to find one. That is crazy. How it's just disappeared off the internet. This is crazy. Yep, I'm not able to find it anywhere. And if it's really from punching the wall, why would they remove it from the internet? You know? Why would they remove it from the internet if it was from punching the wall? Why wouldn't they want anybody to see it? Why wouldn't they show it? They were so bloody and torn up. And they're not gonna, this is crazy. Why? I mean, you're telling me there nowhere on the internet is a picture of his hands? Before he testified, the picture was everywhere. You could find it everywhere. And now It's literally nowhere to be found. That is just crazy. One more try. They're showing all kinds of other hand pictures, but not his. And I specifically put in Chris Melton's injured hands after punching wall. You gotta ask yourself, why are they protecting him so vigorously? I mean, it's beyond obvious that they are protecting him. And I don't understand why. Because they don't want to admit they were wrong in prosecuting Mr. Faust. It's better now than later to admit it. Because if you let an innocent man go to prison over your shoddy investigation, I would think that would be a whole lot worse than catching it now and admitting that your investigation was probably not as good as it should be. And maybe we have the wrong guy and we need to continue our investigation further. Because you've got to think that it's not a good look, right? Sending the wrong man to prison. Which reminds me, after closing arguments when they were discussing the verdict slips, Mr. Cruz objected about something and said that, he wants direct verdicts for certain charges because he feels that the police investigation was poorly done and whatnot. And the judge agrees with him, but she overrules his objection. What? You just said that you agree it was a terrible investigation. And that's what he said. And you're going to overrule his objection? Okay. That's just one of the many examples of the bullshit that Mr. Cruz had to contend with during this trial. And he's a better person than I am because he held his tongue. He showed her the respect that she is entitled because she is the judge. She's not deserving of it, but she is entitled because she's the judge. That's the only, that's the only thing I can say. So anyway, if you can, watch the proceedings on Monday and just get this out there. I mean, it's better late than never, right? I mean, just spread the word that people need to be aware of what's going on here and they need to flood the internet with their presence at the trial on Monday and Tuesday if they don't come up with a verdict on Monday. And they need to bring it to light, the injustice that's going on in Athens, Georgia, and prevent it from ever happening again. And I just hope that Mr. Faust is found not guilty and he can go on with his life. And we just have to believe in our jurors and hope that they do the right thing and find him not guilty. They have more than enough reasonable doubt to find him not guilty. There's so much of it that there's no evidence pointing to Mr. Faust. I mean, there's no sign of a forced entry. Well, maybe Chris had a key, but Mr. Faust would have to force entry into the residence. The deadbolts were all locked from the outside. Well, Mr. Faust doesn't have a key to lock the deadbolts. I mean, there's no DNA or fingerprints or hair fibers or hairs or fibers of Mr. Faust found in the residence, but there were of Mr. Melton, and he supposedly didn't see her. First it was 10 days and then it was 5 days before her death. And her roommate testified that she showers every day. And in fact, they said that she must have just gotten out of the shower when she was unalived because her hair was still wet. And as hard as this is to believe, I'm going to say it, the firefighters even claimed to be able to smell her shampoo still, which I kind of doubt because they wear the big respirators, so how do you smell through those? But that's what they were saying, that she obviously had just showered before her unaliving. So it's like, she must have known who came over, because why would she was nude. I'm not saying she answered the door in the nude, but I mean, would she feel comfortable enough with anybody other than Mr. Melton to enter the door half naked? There's so many questions, and none of them have been answered to any degree of certainty to point to Mr. Faust. So we just got to have faith in our jurors, since we obviously can't count on the judge delivering a fair trial. So hopefully the jury finds him not guilty and they find the real person who did this, because I do not believe it was Mr. Faust. So on that note, I want to thank everybody for watching my video. Please like and subscribe. It's free. And I hope you all have a good rest of your day. And take care, stay safe, stay dry, stay warm, and stay happy. Life's too short to spend your days angry and alone. So till next time, I will see you later. Bye. Thanks.